Question 1. A Florida notary is asked to perform a remote online notarization, RON, for a signer located outside the United States. The signer presents a valid, unexpired foreign passport. Which additional step is required for identity verification in this scenario? A. The notary must have personal knowledge of the signer. B. The signer must undergo knowledge-based authentication, KBA, and credential analysis. C. The signer must provide 2 credible witnesses who are also present on the audio-video call. D. The notary must contact the issuing embassy to validate the passport. Answer: B. The signer must undergo knowledge-based authentication, KBA, and credential analysis. For a remote online notarization, Florida law requires a robust, 2-part identity verification process when the notary does not have personal knowledge of the signer. The signer's government-issued ID, such as a foreign passport, must first be validated through a technology called credential analysis, and the signer must also successfully answer a series of personal questions in a process known as knowledge-based authentication, KBA. These technology-driven steps provide a high level of assurance about the signer's identity, which is critical when the signer is not physically present. A good way to remember this is that RON requires technology to bridge the distance, both for the meeting and for the identity check. Question 2. If a Florida Notary Public officially changes their name, they must notify the Department of State and obtain a new seal within what time frame? A. 30 days of the name change. B. 60 days of the name change. C. Immediately, and cease all notarial acts until a new commission is issued. D. Before their next notarial act. Answer: B. 60 days of the name change. Florida law requires a notary to inform the Department of State of a legal name change within 60 days so a new commission certificate can be issued. Once the amended commission is received, the notary must then get a new seal with the new name. The notary can continue to notarize under their old name until the amended commission is received, but using the new name requires both the updated commission and the new seal. Think of the 60-day window as a grace period to complete all the necessary administrative steps without having to stop working. Question 3. What is the maximum fee a Florida notary may charge for solemnizing a marriage? A. $10. B. $20. C. $30. D. A reasonable fee agreed upon by the parties. Answer: C. $30. While a notary may charge up to $10 for most individual notarial acts like acknowledgments or jurats, the fee for performing a marriage ceremony is specifically set at a higher rate. Florida statutes authorize a notary public to charge a maximum fee of $30 for solemnizing the rites of matrimony. This distinct fee acknowledges the greater responsibility and ceremonial nature of the act compared to a standard notarization. Always remember to consult the state's fee schedule, as specific acts like this often have their own unique limits. Question 4. A document presented for notarization has a completed notarial certificate, but the signer has left a significant blank space in the main body of the instrument. What is the correct action for the notary to take? A. Notarize the signature, as the notary is not responsible for the document's content. B. Fill in the blank space with "not applicable" before proceeding with the notarization. C. Refuse to notarize until the signer fills in the blank space or strikes through it. D. Advise the signer on what information should be placed in the blank space. Answer: C. Refuse to notarize until the signer fills in the blank space or strikes through it. A notary must refuse to notarize a document that contains blank spaces, as this creates a significant opportunity for fraud after the notarization is complete. The notary should return the document to the signer and explain that they must either fill in the information or line through the empty space before the notarization can proceed. This rule protects the integrity of the document and prevents unauthorized information from being added later. The key takeaway is that a notary should only notarize a complete and final document. Question 5. A Florida notary's official seal is lost or stolen. The notary must: A. file a police report within 24 hours. B. Notify the Department of State in writing immediately. C. Order a new seal with a slightly different design. D. Publish a notice in a local newspaper for 3 consecutive days. Answer: B. Notify the Department of State in writing immediately. The security of the notary seal is paramount, and its loss must be treated with urgency to prevent fraudulent use. Florida law mandates that upon discovering their seal is lost, stolen, or broken, the notary must immediately send a signed, written notice of the loss to the Department of State. While filing a police report is a good practice, the legal requirement is the prompt notification to the state, which is the body that issued the notary's commission. Think of your seal as a key to your official power. If it's lost, you must immediately report it to the authority that granted you that power. Question 6. When performing a jurat, what is the most critical action the notary must witness? A. The signer attaching their thumbprint to the notarial certificate. B. The signer understanding the contents of the document. C. The signer personally signing the document in the notary's presence. D. The signer verbally acknowledging that the signature on the document is their own. Answer: C. The signer personally signing the document in the notary's presence. The core purpose of a jurat is for the notary to certify that the document was signed and sworn to, or affirmed, in the notary's presence. Unlike an acknowledgement, where the signature could have been placed on the document beforehand, a jurat requires the notary to physically watch the person sign. The phrase, subscribed and sworn to before me, literally means the document was signed, subscribed, and an oath was taken in the notary's presence. A good way to remember the difference is that a jurat involves the signer's oath about the truthfulness of the document's contents, which is tied directly to the act of signing it right then and there. Question 7. A notary is presented with a valid U.S. passport that expired 1 year ago as proof of identity. The notary may: A. Accept the passport if it is otherwise in good condition. B. Accept the passport only if the signer is personally known to the notary. C. Not accept the passport as it is expired. D. Accept the passport if the signer also provides a current, non-picture ID. Answer: C. Not accept the passport as it is expired. Florida law is very specific about the requirements for acceptable identification, and a key requirement is that the ID must be current or, if expired, issued within the last 5 years. Since the U.S. passport expired a year ago, it does not meet this standard and cannot be accepted as the primary form of identification for a notarization. The notary must refuse the notarization until the signer can provide a valid, unexpired form of ID or use credible witnesses as an alternative. Always check the issue and expiration dates on an ID. An expired ID is not a valid one for notarial purposes. Question 8. A Florida notary who is not an attorney may not use the literal Spanish translation, notario publico, in an advertisement because A. It is a registered trademark of the Florida Department of State. B. It is considered the unauthorized practice of law. C. It falsely implies the notary can offer legal advice like a Latin American notario. D. All notary advertising must be in English only. Answer: C. It falsely implies the notary can offer legal advice like a Latin American notario. In many Latin American countries, a notario publico is a highly trained judicial officer with legal authority similar to that of an attorney. To prevent confusion and protect the public from receiving unauthorized legal advice, Florida law explicitly prohibits non-attorney notaries from using this term. This rule prevents immigrants from being misled into believing that a Florida notary can provide the same legal services as a notario in their home country. The required disclaimer: I am not an attorney licensed to practice law in the state of Florida, and I may not give legal advice or accept fees for legal advice, must be included in any advertisement using the term. Question 9. What is the primary purpose of a Florida Notary Public $7,500 surety bond? A. To protect the notary from lawsuits resulting from notarial errors. B. To pay the notary's salary and administrative expenses. C. To protect the public from financial harm caused by the notary's misconduct. D. To serve as an insurance policy covering any damage to the notary's seal or journal. Answer: C. To protect the public from financial harm caused by the notary's misconduct. The notary bond is a form of consumer protection, not a protection for the notary themselves. It is a surety that guarantees a fund of money, up to $7,500, is available to reimburse any member of the public who suffers financial loss due to a notary's negligence or intentional misconduct. If the bonding company pays out a claim, it will then seek reimbursement from the notary. Think of the bond as a safety net for your clients, not for you. For personal protection, a notary should purchase errors and omissions, (E&O) insurance. Question 10. A Florida notary is asked to notarize signatures on a will. The document contains a self-proving affidavit. The notary may A. Notarize the signatures on the affidavit, as this is a standard notarial act. B. Refuse, as notaries are prohibited from being involved with testamentary instruments. C. Only notarize the will if an attorney is present during the signing. D. Advise the signers that the will is not valid until it is filed with the court. Answer: A. Notarize the signatures on the affidavit, as this is a standard notarial act. While notaries must avoid giving legal advice about the content or validity of a will, they are permitted to notarize the signatures on it, particularly on a part called a self-proving affidavit. This affidavit is a separate statement attached to the will where the testator and witnesses swear before a notary that the will was properly executed, which helps simplify the probate process later. The notary is simply performing a standard notarial act, an oath or acknowledgement, on the affidavit portion and is not certifying the will's legal sufficiency. The key is to focus only on the notarial certificate and not the legal nature of the underlying document. Question 11. Which of the following notarial acts is a Florida notary explicitly authorized to perform? A. Certifying a copy of a birth certificate. B. Issuing a driver's license renewal. C. Taking an acknowledgement on a deed. D. Certifying the authenticity of a court order. Answer: C. Taking an acknowledgement on a deed. Florida notaries are authorized to perform several specific notarial acts, including taking acknowledgments, administering oaths and affirmations, and certifying copies of certain documents. Taking an acknowledgement on a real estate deed is one of the most common and fundamental duties of a notary, where the notary confirms the identity of the signer and that the signer executed the document willingly. Notaries are explicitly prohibited from certifying copies of vital records, like birth certificates, or publicly recorded documents, as certified copies of those must be obtained from the official custodian of the record. Question 12. A Florida notary's commission term is for a period of A. 2 years, renewable online. B. 4 years, expiring on the notary's birthday. C. 4 years, beginning on the date the commission is issued. D. 5 years, renewable with proof of continuing education. Answer: C. 4 years, beginning on the date the commission is issued. A Florida Notary Public commission is granted for a term of 4 years. The commission's effective date and expiration date are clearly printed on the notary's commission certificate issued by the Secretary of State. Unlike a driver's license that might expire on a birthday, the notary commission runs for a full 4-year period from the day it becomes effective. It's a good practice to mark your expiration date on a calendar well in advance to ensure you begin the renewal process on time. Question 13. A notary is completing the venue portion of a notarial certificate, which reads, State of Florida, County of _______________________ dot. The notary is performing the notarization in Miami. What county should be written in the blank? A. The county where the signer resides. B. The county where the document will be recorded. C. Miami-Dade. D. The county where the notary's commission is filed. Answer: C. Miami-Dade. The venue section of a notarial certificate establishes the geographical location where the notarization took place, not where the signer lives or where the document is heading. If the notarial act is being performed in the city of Miami, the correct county to enter is Miami-Dade, as that is the jurisdiction where the notary is physically located at the time of the signing. This detail is crucial because it confirms the notary was acting within their authorized territory when they performed the act. Always remember, the venue is about where you are, not where they're from. Question 14. A notary is asked to notarize their own signature on a personal loan application. This action is A. Permissible if a second notary is present to witness the act. B. Permissible only if the notary does not charge a fee for the act. C. Prohibited because a notary cannot be a party to the document they are notarizing. D. Prohibited because notaries cannot notarize financial documents. Answer: C. Prohibited because a notary cannot be a party to the document they are notarizing. A fundamental principle of notarial practice is impartiality, and a notary cannot act as both the notary and a principal signer in the same transaction. Notarizing one's own signature creates a clear conflict of interest and invalidates the notarial act because a person cannot officially witness their own signing. This prohibition applies to all documents, regardless of type, and is one of the most important rules to prevent self-serving fraudulent acts. The simple rule to follow is that you can never be the notary for your own signature. Question 15. A Florida Notary Public may certify a copy of which of the following documents? A. A United States passport. B. A last will and testament. C. A university diploma. D. A marriage certificate. Answer: A. A United States passport. Florida law allows notaries to make attested photocopies, also known as copy certifications, of certain documents, but with important restrictions. The notary can certify a copy of a document that is not a vital record or a publicly recordable document, and they must personally supervise the photocopying process. A U.S. passport fits this criteria, whereas vital records like marriage certificates and public records like court-filed wills must be obtained as certified copies from their official issuing or recording agencies. Think of it this way: if a government office holds the original and can issue a certified copy, a notary cannot. Question 16. A signer appears before a notary but does not have an acceptable form of identification. The signer brings a friend to act as a credible witness. The credible witness must A. Sign the document on behalf of the principal signer. B. Swear or affirm to the notary that they personally know the signer. C. Provide two forms of their own government-issued identification. D. Be a family member of the principal signer. Answer: B. Swear or affirm to the notary that they personally know the signer. When a signer lacks proper ID, a credible witness can be used to vouch for their identity, but the witness must meet specific criteria. The credible witness must be personally known by the notary, must personally know the signer, and must take an oath or affirmation before the notary stating that the person signing the document is the individual they claim to be. The witness is essentially lending their credibility, and their own identity which the notary has verified, to the transaction. Remember, the witness's role is strictly to identify the signer, not to sign or comment on the document itself. Question 17. A notary is asked to notarize the signature of their spouse on a warranty deed for a property they own jointly. The notary should A. Proceed with the notarization since they are a commissioned officer. B. Proceed, but note the spousal relationship in the notarial journal. C. Refuse, as the notary has a direct beneficial interest in the transaction. D. Ask another notary in the office to perform the notarization. Answer: C. Refuse, as the notary has a direct beneficial interest in the transaction. A notary public is disqualified from notarizing any document in which they are a party or have a financial or beneficial interest. In this case, because the notary jointly owns the property, they have a direct financial interest in the transaction conveyed by the warranty deed, making it a conflict of interest to notarize their spouse's signature. Even if the notary's name wasn't on the deed, Florida law specifically prohibits notarizing a spouse's signature on any instrument that transfers or encumbers real estate. The only proper action is to have a completely impartial notary perform the act. Question 18. What is the fundamental difference between an acknowledgement and a jurat? A. A jurat requires a thumbprint in the notary's journal, while an acknowledgement does not. B. An acknowledgement confirms the signer's identity and willingness to sign, while a jurat also involves an oath about the document's truthfulness. C. An acknowledgement can be performed remotely, while a jurat requires physical presence. D. A jurat is used for real estate documents, and an acknowledgement is used for all other documents. Answer: B. An acknowledgement confirms the signer's identity and willingness to sign, while a jurat also involves an oath about the document's truthfulness. The key distinction lies in the statement the signer is making to the notary. For an acknowledgement, the signer simply acknowledges that they signed the document for the purposes stated within it, and the signature could have been made before seeing the notary. For a jurat, the signer must sign in the notary's presence and swear or affirm that the contents of the document are true and correct. An easy tip is to look for the key words in the notarial certificate. Acknowledged before me signals an acknowledgement, while sworn to, or affirmed, and subscribed before me signals a jurat. Question 19. A notary who is not an attorney is helping someone fill out an immigration form and charges a $50 fee for this service. This act constitutes A. A valid service, as long as it is not advertised as legal work. B. The unauthorized practice of law, UPL, which is prohibited. C. A permissible clerical fee, as long as it is recorded in the journal. D. A standard notarial duty for non-attorney notaries. Answer: B. The unauthorized practice of law, UPL, which is prohibited. A notary public who is not a licensed attorney is strictly forbidden from giving legal advice or assisting in the preparation of legal or immigration forms. Choosing which form to use, explaining a form's meaning, or helping someone fill it out constitutes the practice of law, even if no fee or a small fee is charged. Engaging in such activity is considered the unauthorized practice of law, UPL, and can lead to severe penalties, including the revocation of the notary's commission and potential criminal charges. The notary's role is limited to performing the notarial act itself, not preparing the document. Question 20. Under Florida law, a notary is required to keep a sequential journal of notarial acts for A. All notarial acts performed. B. Only notarial acts related to real estate transactions. C. Only remote online notarizations. D. Only when the signer does not have proper identification. Answer: C. Only remote online notarizations. While maintaining a journal for all notarial acts is considered a best practice to protect the notary from liability, it is not legally required in Florida for traditional, paper-based notarizations. However, the law is different and stricter for remote online notarizations, RON. For every RON performed, the notary must keep a secure, electronic journal with specific, detailed entries for each transaction, including a recording of the audio-video session. The key distinction to remember is that the advanced technology of RON comes with advanced record-keeping requirements. Question 21. A person who is legally blind needs to have a document notarized. How should the Florida notary proceed? A. Refuse the notarization as the person cannot read the document. B. The notary must read the entire document aloud to the signer before notarizing. C. Require 2 credible witnesses to sign on behalf of the blind person. D. Proceed with the notarization if the notary is satisfied the signer understands the document's contents. Answer: B. The notary must read the entire document aloud to the signer before notarizing. Florida law provides a specific procedure for notarizing the signature of a person who is blind. The notary must read the entire document aloud to the signer in the presence of 2 disinterested witnesses who are not named in the document. After reading the document, the notary must then ask the signer if they understand the document and wish to sign it, and the notary should note this procedure in the notarial certificate. This process ensures the blind individual is fully aware of what they are signing, protecting them from potential fraud. Question 22. A Florida notary has moved to a new residential address within the state. The notary must notify the Department of State of this change. A. Within 60 days of moving. B. Before performing any further notarial acts. C. Only when it is time to renew their commission. D. Notification is not required for a change of address, only a name change. Answer: A. Within 60 days of moving. A notary public is required to keep their contact information current with the commissioning authority, which is the Florida Department of State. If a notary moves, they must provide their new residential address to the department within 60 days of the change. This requirement ensures that the state can always contact the notary with official correspondence or in the event of a complaint. A helpful way to remember this is that both major changes, name and address, have a 60-day notification deadline. Question 23. In Florida, a notary public is commissioned by A. The County Clerk of Court. B. The Governor of Florida. C. The Florida Department of State. D. The Florida Bar Association. Answer: B. The Governor of Florida. While the Florida Department of State handles the application processing and administration of notary commissions, the actual appointment authority rests with the state's chief executive. A Florida notary public is officially appointed and commissioned by the governor. This designation underscores the importance of the notary's role as a public officer entrusted with serving the citizens of the state. Remember to think of the governor as the one who grants the official power, and the Department of State as the office that manages the program. Question 24. A notary is asked to notarize a document written in Spanish, a language the notary does not understand. The signer appears to understand the document and has provided proper ID. The notary should A. Proceed with the notarization since the notarial certificate is in English. B. Refuse to notarize the document. C. Use an online translation tool to understand the document's general purpose. D. Ask the signer to verbally summarize the document's contents in English. Answer: B. Refuse to notarize the document. A notary cannot notarize a signature on a document if they cannot understand the language in which it is written, even if the notarial certificate is in English. This is because the notary must be able to scan the document for completeness, ensure there are no blank spaces, and be certain it is not a document they are prohibited from notarizing. Notarizing a document without being able to read it is a breach of notarial duty and exposes the notary to significant liability. The rule is simple: if you can't read it, you can't notarize it. Question 25. For a remote online notarization, RON, in Florida, the audio-video recording of the notarial act must be securely stored for a minimum period of A. 3 years. B. 5 years. C. 7 years. D. 10 years. Answer: D. 10 years. Florida's remote online notarization laws include strict requirements for creating and retaining evidence of the notarial act. The full audio-video recording of the RON session, along with the entries in the electronic journal, serves as the official record. State law mandates that the notary, or a secure repository on their behalf, must retain this recording for a minimum of 10 years. This long retention period ensures that a verifiable record of the transaction is available for a significant time in case of any future legal challenges or disputes.